just to make sure nothing's changed, I remember things correctly, and that my calendar is following that the deadlines and the requirements of Rule 26.
Yeah, and I am surprised oftentimes about how seldom we make time to actually check the rules every time we go to do a disclosure or to, request something, because the rules do change, and it never hurts to get a little refresher and get caught up on what the requirements may be. So I try and make a point of going over it. Every time a particular rule comes up, I'll pull out the book and go through it. But with some of them, like some of the expert disclosure rules, they get very complicated very fast, and so you better spend enough time with it. Otherwise, you're going to get lost. But it's the worst kind of lost. It's where you feel like you know where you're going, but you're really wrong.
Right, and we'll get into those, specifically the expert disclosures. I think expert disclosures are big nowadays. Review Rule 26. We mentioned your calendar. Interestingly, I'll start with a quick war story. I had a trial years ago where it was a missed statute of limitations, and the opposing side brought in an expert who I still practice law with. I have great respect for her. And something he said has stuck with me ever since that trial. He said every attorney should have belt and suspenders for their calendar, which means don't just rely on your Outlook. Have a secondary method in which to keep track of especially important deadlines. Because I remember at the time, all I had was Outlook, and I was very fastidious about keeping my Outlook up to date, but it dawned on me that I should have belt and suspenders.
And I think it helps a lot these days if you use, obviously they could all fail in series, but I use a different, I use Outlook for my calendar, a different program for my for my case management stuff, but the calendar syncs across everything.
Right.
And so, like, if I were to lose it from there, the rule used to be, I think we had a malpractice insurer once who wanted us to print it out in a physical hard copy every 3 months. I don't know if you would have to do that anymore. The real trick is finding something that works for you, and then if that fails, something that could still save you.
Right, and that's why I really wish I could come in today and say I've got this magic recipe for the secondary source, but really it depends on practice to practice and what works for you. For example, in my practice, something that, and this is going to date me a little bit, but when we used to have paper files for every file, I would make sure that every month the paper files was on my desk, the tangible file, and the file wouldn't go back into the filing cabinet until I had done a status report to the client and looked through the file, and that way I made sure I laid eyes on every case once every 30 days, figuring that at that point, between that and the calendar, there was no way I was missing deadlines. Come up with some kind of diary system within your own that works for your own practice to make sure you're laying eyes on your cases routinely, and that way you've got that belt and suspender. So,
and with a lot of the new tools and AI stuff, part of the benefits of increased productivity is it should make it easier for you to keep up with everything.
Yeah.
If there's less minutia that you have to mess with yourself, oftentimes you're going to be better about the calendar and being more prepared.
So let me ask you this, Gabe, because I think this is something you're probably better suited to talk about. One of the big areas that I see routinely come across...
Is this another corpse disposal question?
Yes.
I feel I've been warned because you said this is one for me, and so... Okay, continue.
That's clearly your area of expertise. Let's go to your secondary.
Secondary. Okay, sure.
Working from the plaintiff side.
Yeah.
I see a lot of cases come across my desk where there's a disclosure damages issue. That's and I'll freely confess that as a defendant, I often rely on failure of plaintiffs to disclose their damages. I try to be fair and give them plenty of warnings of I don't think you've disclosed your damages. Please provide me your damages, and if they still fail to, I think it cues up that keystone type motion that is getting more and more successful. And even if you read the committee notes in the rule,
I think some of them, I mean, the facts on the ones where it succeeds are often very different, the facts on the ones where it doesn't. I do think that because there is some ambiguity in this rule as to the level of detail that is required, that, you know, I have gotten, but I think asking for more specificity is good, as long as what you're really doing is asking for more information. Oftentimes I will get requests that the most charitable way I can describe them is they're just kind of dumb, like asking me for a precise calculation of general damages. Or then saying, well, you know, you haven't given me a precise calculation of your total damages. And it's like, yeah, because that includes general damages, which by definition are not subject to precise mathematical calculation. So we do get a fair amount of game playing with this rule. I have not run into it as a problem with the judiciary, because my response when this comes up is to kind of fall back on reasonableness. Okay, because the rule doesn't really specifically lay out how specific, or it doesn't clearly lay out how specific you need to be. So, you know, I will try and figure out, okay, what do they really need to know? What, you know, if I get a response from opposing counsel that says, hey, we don't think these are good enough, you know, my usual response is to call and ask, you know, well, okay, tell me a little more about that. I mean, the more specific the requests are, the happier I've provided. That's the other thing I should say. On the plaintiff side, the disclosures are a little bit different. I mean, I won't take a case if I don't feel confident with all of the information that I know. You know, everything that I've gotten from the clients, everything that I've been able to uncover myself. And so disclosures are not a matter of trying to hide anything. It's just trying to get the information out the door as efficiently as possible so that we can move the case forward. I mean, we know we have the burden of proof, and, you know, that's kind of a precondition that I have for taking on cases is, you know, that I got to feel confident, and I don't want to spend the whole case trying to make sure you don't look one way or the other. You know, my clients have rights, and I have an obligation to protect them, so where I have to step in or something's not relevant or whatever, then we can deal with that. But by and large, if you ask me for something and it exists, I'm gonna give it to you. And if it turns out to be bad, I want to know that too, because, you know, I may not be interested in the case anymore. If it's really bad, if it's bad as it could be, whatever this information you think is there is. Because I don't want to make bad investments. So the procedural or the realistic position that we find ourselves in, plaintiffs versus defense, diverges quite a lot when it comes to these kind of things. And I find that so long as I'm dealing with somebody who's actually trying to get some piece of useful information that they can articulate specifically, like say, well, yeah, we said we need more of this, but here are the kind of documents we're looking for. You know, do you know anything about that? Well, I don't know, I'll ask my client. You know, that usually turns out really well. And the other kind, you have not given us sufficient detail as to your general damages, folks. Generally, they don't wind up filing motions on it because they know that it's as weak as I do. And if they do, I win them, generally. Because again, I don't think most judges want to spend their time policing meaningless little disputes over, you know, what level of detail you got. I think they want you to just do your best to follow the rules and then let's move forward. And, you know, like I said, if everybody's acting in good faith, it doesn't wind up being a problem.
So let me jump on that, and I realize that giving this advice, it may be taking bread out of my own mouth, but I'm a big advocate for giving the other side the benefit of the doubt and trying to work with them rather than ambush them. It was interesting, I had this discussion with an associate this week that we were talking about how to handle a particular case that all of a sudden became unexpectedly hairy. And one of the approaches that was suggested to us was, well, let's lay in wait, let it really become hairy, and then ambush and I said, I don't practice that way. I'm a big advocate of, but by the grace of God, go I.
Well, and a lot of the time, it's a waste of, most of the time, it's a waste of time to do that, because even when somebody's tripped up, the rules are, very much geared towards not having defaults, like not resolving cases otherwise on the merits, and there are all sorts of, if it's reasonable neglect within this time frame, and so, generally it is a waste of time to fight those battles.
To the point that if you look in, it was 2024 now, I believe the case is called De La Cruz, that I believe it's a concurring opinion by Judge Harris, who I have great respect for.
Yeah, he's great.
And in that concurring opinion, he specifically says, hey, trial courts, let's try to err on the side of deciding cases on their merits rather than on technicalities. And I feel like, especially with the evolution of Rule 26 that has so many built-in deadlines, I feel like we are starting to try to be a little bit more, I'm going to get you on a technicality.
Right. Well, and
I don't like practicing law that way.
And I think it arises, this is based on my admittedly limited understanding of the reasons for the 2011 changes, but my understanding at the time was that they were trying to fix a problem that was primarily commercial litigation cases, and there was lots of gamesmanship and spending unreasonable amounts of time and discovery. In fact, I remember the biggest thing they stressed was actually how the discovery would be tiered, which people don't talk about as much anymore because it hasn't been as much of an issue. But and it feels like that has kind of led us into this really regimented sort of thing. Whereas, in the past, you'd still have fights, but the council would get together and be like, okay, here's the deadlines we want. And the court would just kind of sign off on it. And so long as there's no client getting screwed because everything's reasonable, then that seems like an easier system. But I got the impression that we don't have that anymore because these cases were proving so contentious or expensive that they needed to change all the rules.
And remember, as we talk about this, remember that there is in the rules of civility and civility and what's the other word I'm looking for?
Professionalism and civility.
Professionalism and civility. Thank you. Although the client has say in procedural steps in your case, you as the attorney should and can maintain the position for granting extensions and allowing people to, and
the part that I've always struggled with that, because I like to grant extensions, and I've had some attorneys treat it as different if, for example, the deadline that they're trying to extend has already passed. That now the client technically has some advantage and they've got to, either they can't go back to the client, and I don't know that I agree with that standard, because I think generally kind of the common law approach was ends versus means distinction. The client's entitled to choose the ends, but I got to choose the means. But I don't know if there's any validity to that, and whether that's something that I need to, because there have been cases before where somebody's like thought they were responding on behalf of, I think one in specific, really nice opposing counsel, I felt really bad, but it's like, okay, they were responding on behalf of one defendant, they were supposed to be responding on behalf of two, like 4 or 5 months had gone by, we just hadn't defaulted them because we usually don't worry about it, and so now I'm in this quandary, like, do I need to stipulate to do this? And I don't, the best I could come up with was, well, you go ahead and file a motion, but I won't oppose it, which doesn't seem like it does anything, but for some reason at the time it felt like better than just saying no, and I'm gonna fight you.
Right.
But yeah, I don't know specifically if that change has any substance behind it.
Right. All right, so you mentioned it, so let's talk about it a little bit, because I think Rule 26, it's pretty laid out. If you review it, you understand it, you'll know your deadlines. I give one exception to that, which is expert discovery. Expert discovery.
Yeah, you do that without a chart at your peril.
Right. All right. So, quick overview, I think everybody understands, but expert discovery doesn't have set deadlines of it will start on April 1st. Instead, it has triggering dates that become fluid as you go through litigation. So it's not something you're able to map out. And it's funny, I had a secretary try doing this once, of mapping out what the expert discovery deadlines should be if the case went perfectly to calendar. And we quickly realized that was more detrimental than just staying on top of it, because we'd have ghost deadlines on the calendar. It would mess us up.
It gets really freaks people out. Yeah.
So to start, I hope we all understand. If not, review Rule 26. But there are triggering dates that start expert discovery. For plaintiff, I should be careful. I shouldn't say plaintiff.
For the party bearing the burden of proof, which most of the time is the plaintiff, it's triggered after the close of fact discovery. I think 14 days.
14 days after the close of fact discovery.
So they wanted to pick a round number.
Right. Yeah.
14.
But Gabe mentions an interesting point of that the rules said, and I've had this fight, which again, I think we're getting into the technicalities region, and I don't like litigating that way. But I've had people say, well, it says burden of proof. So even as a defendant, if you've got an affirmative defense.
Yeah, and I mean, this is one, I struggle with what to do with this as well, because this is one I would love to sit down with opposing counsel on the cases and just say, okay, when are you going to give me, whatever experts you're going to give me, when can you give them to me? And that way we don't have to dance around like who's on which side of which issue, and just let's come up with some rules we can both agree to. The problem is that usually when you do that, whoever might be slightly inconvenienced by it will say, no, we'll use the default rules, and we're back right where we started.
Right.
So, but yeah, it is a fertile ground for getting malpractice finding.
One of the business practices we've done at our firm that I like is that you'll know that once you file your responsive pleading, you get the notice of event due dates from the court, and that's really the calendaring deadlines that you get outside of then what triggers off of Rule 26.
Mm-hmm.
What I'll often do, especially in a case where I anticipate there may be this burden of proof type issue, or there's multiple defendants, or there's third-party defendants that mucks it up even more, is that right after I get that notice of event due dates, I'll draft my own case management order that lays out, let's agree that plaintiffs specifically will designate their experts by this date, that the first party defendants will designate their experts by this part, the third party defendants.
Yeah, and what's going to be feasible / fair is going to vary quite a bit from case to case or situation to situation, But the more you can work together, the more life gets easier.
Well, and what I've noticed is that most attorneys, regardless of what side of the fence they're on, appreciate that, because again, it's something more definitive that you can plug into your calendar once and then not.
Plus, if you do it at the beginning, not everybody's got the same stakes they're going to have later. So if you it's kind of like going into business, you want to make sure you've got it in writing how you're going to get out of business. If you've got it set in advance, it's not going to be mucked up by somebody's expert saying, oh, can you give me more time?
Right. And so that's the second pitfall. That I admit, I haven't had attorneys die on this hill, but I have had it rise up of that when, for example.
But you guys actually submit it to the court, like as a stipulated?
Yes.
Like a Rule 29 stipulation or whatever?
Right.
Then I think that should hold up.
Right. And I've never run into a problem with it. And honestly, again, that's one of the benefits of practicing in Utah, is that it's still a small enough community. We run into each other a lot, and so everybody cooperates well. And so I've always found if you have that case management order in place, we're good to go. The second pitfall I think that helps avoid, this is the second pitfall that I admit that I've run into, but nobody's ever died on this hill, and so it hasn't become a big issue, is the idea of, for example, if Gabe is the burden of proof, and he has 2 different experts, and I ask for a report and a deposition, and he gives me the report right away from one of them.
Mm-hmm.
Technically, under the rules, my time...
You only get one or the other.
Right. So I asked for a report from one expert, the deposition of the second.
Okay. No, I got that.
And so he provides me the expert report for the first expert immediately, and the deposition for the second expert isn't until 28 days later.
Mm-hmm.
Technically, under the rules, Gabe could say, hey, you've got the report from my first expert, the 14-day window for you to now do your rebuttal expert to that expert is... And I've had attorneys, that's what I say, I've had attorneys take that position. Luckily, none of them have ever died on that hill.
The text of the rule is that painstaking, and there are probably good reasons why. Because I think you can go back and forth about, okay, well, I have the burden of proof on this claim, you have the burden of proof on the affirmative defense, but there's an aspect of the affirmative defense that requires something that I have to prove. And so, do I have some burden of proof with regard to this? What if I need to present expert testimony on it? I mean, that's why I generally, it's the same reason why I still generally prefer expert reports, because I get everything the expert can say, basically, in a single document that then I can cross the heck out of them on. But yeah, those rules, I think we get saved from doing that more often by people just not wanting to be that wasteful of time.
Right. So again,
doesn't mean it can't happen.
Right. So again, understand the rules, understand the triggering events, and as much as possible, anticipate in advance and work with opposing counsel to have a set calendaring layout so that you don't get caught up in any of those pitfalls.
Yeah, I mean, the more that you can be in contact with opposing counsel and keep, because again, yes, is it possible you'll get some benefit by your opposing counsel missing a deadline or not showing up for this or that or the other? Possibly some short-term benefit, but the reality is 99% of the time they're going to come back afterwards and say, whoops, my mistake, and it's going to be set aside.
Right.
So yeah, you couldn't fight and die on every single one of these hills hoping that one of them, but what you're going to wind up doing is the judge is going to start to see every request you make as unreasonable before you even open your mouth.
Right. All right, 2 last quick deadlines I want to highlight because I see these often as well, is that, and this one, it surprises me how many attorneys are surprised by this, is the dispositive motion cutoff that's also built into the rules. If you review Rule 56, it has a specific deadline under which you must file dispositive motions, and it's within 28 days of the close of all discovery. So once expert discovery is done, you have a very limited 28-day window in which to file your dispositive motion. Now again, I've seen judges who are more lenient, and if you file one after that 28 days, they'll say, hey, if it's a legitimate dispositive motion that will help me resolve some of the case, I'll entertain it. But they don't have to. And if they want to say, sorry, it's beyond the 28 days, I won't even entertain it, now you have to explain to a client why a possibly important dispositive motion was never presented to the court.
I am familiar with that deadline. The only issue I have with it is it's like, well, so if something's fatally defective with the case,
right,
we're going to let it go all the way up to, and then we're going to have a motion for directed verdict.
Right.
Yeah,
right.
Like I haven't run into it, frankly, because for the most part, my cases are either don't use up the whole expert discovery window, so we've got a big space of time at the end of it, or there are cases where there's a lot of experts and things, and there's a lot of people that are on it, and so when deadlines get close, they get moved. But yeah, I mean that could be a big problem.
Right. And then the final one I'll put on everybody's radar is the pretrial disclosures are also built into the rule. Now, typically when you set trial dates, the court proactively either does it on their own or has one of the attorneys provide an order outlining the pretrial deadlines, jury instructions, voir dire questions, pretrial disclosures, exhibits, things of that nature. But I've come across cases where there was no pretrial order. The rule says 28 days before trial you have to provide your pretrial disclosures, and I've had attorneys miss that deadline and now have to explain to a client why the case got dismissed because no disclosures were made.
Or I mean, even in the best case, the case got continued, right? And a lot of times by the time the client gets down to trial, we're looking at a serious delay. And, one of the things I hear the most from clients is like, how long is this going to take? Because it still shocks people how long the legal system takes. So by the time you get to trial, clients are usually pretty raring to go.
Right.
And I've had clients, even when we needed a continuance and barely got it by the skin of our teeth, still are kind of pissed that that things had to get put off.
Right. Okay. So, in my mind, those are the big calendaring items to be aware of. So let's talk a little bit about communication, and I think specifically this is important for the plaintiff side. Obviously, when I'm representing corporations, when I'm representing insurance companies, they obviously like to be in the loop and communicated with. However, the malpractice cases I see that come across my desk because of lack of communication are usually because on a plaintiff side that is, and someone's not kept up to speed.
That's that is, as long as I've been going to the CLEs about, put on by the ethics folks, that's been the most frequent complaint that clients have. I have kind of my own personal solution to it, which is I give my clients my cell phone number. So if they're looking for me, at least I know about it. It's not like they're calling my office. And, knock on wood, whatever, clients have generally been really respectful with it. Occasionally I run into problems where they're, calling the staff because they don't want to bother me because, but it certainly resolves any complaint that they can't get a hold of me because, I'll either pick up, or if I can't, I call them right back as soon as I get out of a meeting. Now, this works also because I, have a reasonable caseload. For one plaintiff's attorney, what that is going to vary based on your circumstances. I will say, it has been surprising recently, been visiting some newer plaintiffs firms in town, and it's just been surprising to me how little kind of background there is. And often I saw one firm a while ago that had I think I counted 28 staff members and one attorney. Now, doing plaintiffs litigation, that attorney's got to be handling, to be supporting that many people on staff, has got to be handling 300-400 cases at one time. And I assume there probably are people who can keep in touch with that many people at the same time. I couldn't, and so if I ever got to the point where I felt like my caseload was getting to make it difficult to be able to communicate with the clients, I would hire another attorney to work there. As expensive as that can be, it really helps the clients feel like they're getting the kind of personal touch that they're entitled to. And it's not just enough to give them access to your staff, because when somebody retains you, the value of that agreement is completely dependent on your advice. I can't remember who used to say it about, I think it was about management consulting firms, but the same holds true with law firms. Is they're like any other business, except all of the assets go up and down the elevators every day, right? And once the people walk out the door, there's very little value in the shell that's left. And I think, that the same could be said for the representation. If the clients don't have access to the advice of a lawyer, then, you know, what is it they're really getting out of this? You know, presumably you're going to want to make decisions with the client before things happen. I see more and more less of that happening as well. Like, you know, cases where settlement offers have been made and clients have not been consulted can be a problem, because if the client finds out later and gets upset, you know, you may be dealing with bar complaints or with a lawsuit, regardless of whether, you know, let's say, I'll give you an example. In the insurance case, the insurance company oftentimes has the right to make decisions regardless of what the client thinks. Now, I think that sometimes when we get really busy, we tend to interpret that as the client doesn't, if they're an insurance client, they don't necessarily need to weigh in as much. And that's not true. I mean, it just as the insurance company is a part of that tripartite relationship, so is the actual client. Now, they may not have the ability to say no, but, you know, they deserve to be a part of that conversation. And I think, you know, maintaining these kind of relationships and these kind of conversations is what helps avoid, you know, a plethora of other problems. Because if your client can talk to you, get information, and resolve their concerns, you know, there's a lot less likely that they're going to be taking it up with somebody else.
It's just the phrase you used that I loved is the personal touch. Interestingly, a lot of what my firm does is medical malpractice defense. And so every so often, the attorneys that do the medical malpractice defense work will go and talk to doctors and hospitals proactively and give a similar type of lecture about here's some ways to avoid malpractice. And the number one advice they give is your bedside manner.
Be nice.
Yes. Yeah. That if you've got a good bedside manner, even if things go south in a surgery, if you have that personal touch, that personal relationship with the patient, you're less likely to get sued. The same is true in the legal world.
Yeah.
If you've got that personal touch, where even if you use your best judgment and something goes south in the case, if you've been communicating with the client, if you've been keeping the client up to speed on what's going on, if you've been available and responsive, you're less likely for that client to leave disgruntled. And
it's even more important with our thing because it is rare. I mean, I guess it's not rare. A much smaller percentage of complaints against doctors and hospitals have to do with lack of communication. Mostly, you know, it's something was done that shouldn't have been done, or something wasn't done that should have been done. But with attorneys, man, this is like a major element of so many malpractice claims, is that, you know, maybe there was something the attorney needed to know, but the client couldn't get a call back, and so decisions were made, and the client was consulted but didn't really understand what was going on, but it was really quick, and the decision got made, and the client felt like the attorney didn't really tell him what was going on. Well, then if anything happens later and something goes wrong, they're going to be looking first like, well, maybe the problem wasn't, you know, that we lost the case. Maybe the problem was something else the attorney didn't tell me that was going on. Right? Or some decision that he or she made without talking to me. And I think that, you know, you get the extra benefit of them liking you. Okay. I think that they're, to a certain extent, they're never going to like you as much as they like their doctor. But I mean, no matter how nice you are. But you know, the reality is I think that being in touch with them may make them feel more comfortable raising issues with you, and you can resolve things before they get, you know, out of control.
Right. Key point of that he had mentioned as well is that not just communication, but have it papered in your file. Too many times I'll be trying to defend a malpractice action, and my client will say to me, I know we talked about that. I talked about that with the client multiple times. Okay, but if I'm not seeing something in writing in the file, that makes the defense of the malpractice harder. In cases where I've got an email where I can slide to the other side and say, this email was sent to you that lays out exactly this issue and what was going on. It's copied to you, it's copied to your spouse, it was sent to you 2 different times, 3 different times in different status reports.
Well, and
that's
you,
huge.
You know which the important is. I mean, you're usually on a case, at least from the plaintiff side, 2 maybe points in the case, 2 or 3 points in the case where me and the client talking, could create problems if there are misunderstandings. So sometimes, depending on who I'm talking to and where they are and, what their phone system says, I just record the call.
Yeah, no, that's
and
smart.
then
Smart.
99.99% of the time, I never listen to it or even realize it's even still there because it doesn't come up. But once or twice, where somebody said that I said something that I didn't say, having that file that I could search and forward out in an email changed things like really fast, which was awesome.
The other thing, and this is just a personal, not pet peeve, but a personal thing that's hit home to me, is when you make significant.
Peeve.
Yeah, I guess
That's
so.
what it is.
I guess
Yeah.
by definition, it is a pet peeve. Is when you make big strategic decisions, document it. For example, I'll have associates come in and I'll say, hey, I think we should file a motion for summary judgment or partial summary judgment on this case. And they say, okay, let me go look at it. And they come back and they say, I do research. I think it's an uphill battle. I don't think we should file it. It's not going to win. And I say, all right, we need to pass that by the client to say, we have thought about this and we think it's unlikely to succeed because of this. Let us know your thoughts. And they say, well, if we've already vetted it out, why do we? And I said, okay, put yourself in the malpractice suit to come. The next attorney that's reviewing our file is going to want to see in there the associate coming in and saying, well, I thought about that motion and I just didn't think it was a winner, so I didn't do it. Okay, that's a little bit of a defense. But if you say, I thought about it, I determined it was not going to be successful, and I laid it out to the client that I had done that thought process and ruled it out. So the client at any point could have said, file it anyway, do it anyway. Then you're in a better position. So the idea, and it's not just with motions for summary judgment. Say it's I'm going to take this.
So I would say, though, the biggest concern I have with that process is the time, right? If you apply that to every issue, you'd be there all day. So I think that's where it comes in. Summary judgment motion on a big case where the client was expecting, like my clients are almost never expecting to file a summary judgment motion. Most of them have no idea what that is, but even if they did, plaintiffs just don't file them as often. But if it's a major thing and the client was expecting to have this as an option and it turns out it's not, from a client perspective, you're probably better off just talking to them and documenting it.
Let me give you another example that'll resonate with both sides of the fence. Expert retention. Mm-hmm. So for example, you look at a file and you think, well, do I need this type of expert? I don't think I do. I think I'm okay without it. And you make that decision. Fine. Document it, send it to the client and say, unless you disagree, this is what I'm thinking and we won't get this type of expert. Or unless you disagree, I think we need this expert. Please let me know you approve. Again, you don't want to be making these substantive decisions internally without documenting and let the client at least have a chance to weigh in if they disagree with your position. But it has to be it's substantive.
Well, and I remember, again, it's been a long time since I did the defense work. You can tell me if this has completely changed, but I remember.
It's gotten better since you left. I'm not sure there's a correlation between it.
Because I remember there were just these massive forms, for the reports. So you'd get a brand new case in, and I could see that it was headed to be resolved in a month or 2. They'd want a 40-page report on it. And I get, okay, they're just covering all their bases and everything. But to the extent you can say, hey, we're gonna do that a little bit, and I'm gonna give you some more information, because I can't tell you how many times I would send that form in, and then the next day get a phone call from that adjuster. Or they resolve it, or get a phone call from that adjuster saying, hey, tell me what, I got the new report in from you, so tell me what's going on in the case. Right? And it's like, well, okay, now the insurance company's paying twice for this, and most of the time it's stuff that I could tell you in a couple of minutes anyway. So it does get easier on the plaintiff side because we don't have those kind of forms. We'll kind of just talk through with the clients over a few minutes, but you got to also know your clients really well, which comes from talking to them more than once. Some clients have a great deal of understanding, and others, boy, they really do not. And they're going to need things explained to them at a different level. And that's, not to say people are dumb, it's just people have different levels of understanding. And, if you think the client is totally on board with you, or is, is way smarter than they actually are, you can wind up with the client sitting next to you who, has no idea how to follow your instructions, and you just don't know because you haven't been keeping in close contact with them.
Right. Okay, so we've covered really the two big categories that stick out in my mind: calendaring, communication. For the last 10 minutes or so that we've got, I thought we'd discuss a couple of just random bits of advice.
Let's do it.
This one may sound a little odd, but it's the first one that pops into my mind whenever I think about avoiding malpractice. And that is, don't sue for your legal fees.
Yeah.
If you haven't experienced this, let me lay out what will happen if you do. Too many cases come across my desk because the attorney sued for the collection of their fees. The natural reaction and the natural retaliation for the client is going to be a countersuit for malpractice. Because if they didn't pay the fees, it's likely they don't have the money to pay the fees, and so the only way out of having to pay those fees to you is now to sue you for malpractice.
Create something they can trade for it.
Right. So, and interestingly, if you work through your insurance applications for malpractice coverage,
yeah, you have to mark that down.
that's one of the questions they'll ask is, do you sue for collection of your fees? Because they know that increases your chances of being
It's just penny wise and pound foolish.
Right,
Really.
right. So and the second one I thought of, and I'll put this to you, Gabe, because I think this is not your corpse disposal expertise, but your
the other one.
other expertise.
Okay, the other one. Yeah.
Is not biting off more than you can chew, whether that be amount of work or competency of the issue that is presented.
Yeah, and I think that happens, that happens a lot on my side in two contexts primarily. One is I will see people who are moonlighting. I've actually recently seen some firms that have just gotten some billboards, and you go to their website and it does say personal injury across the top, but nobody. I mean, if anybody there has personal injury experience, they're keeping it to themselves because it's not listed there. And so, when I see that, I think, okay, somebody's been told that 90% of this business is just getting the clients in the door. And that is a recipe for short-term success, long-term failure. Because if the legal work doesn't hold up, people will find out very quickly. And, personal injury on the plaintiff side is subtly it's not like a lot of other practice areas because of the financial arrangements that you're involved in and the risk that you have to analyze, and you kind of have to look at the case both as a lawyer and almost like a venture capitalist. And there are a lot of things that are different in terms of the burden of proof being on the plaintiff for the kind of main elements of the cause of action kind of lays things out in the way they go through the litigation. And, if you don't know what you're doing, the other one I see is at firms where that really is kind of the engine is just kind of churn and burn, bring in a lot of clients and get them out. A lot of times they're not super great about handling the cases that they're not going to take. They'll send the clients kind of I've talked to several from major firms like this, and they'll call me up and say, yeah, I got this letter in the mail from my attorneys. It just says they can't represent me anymore. It doesn't give them a reason why, doesn't explain what they should do next. Sometimes it doesn't even explain when the statute of limitations is going to run. And I get a real sense that it's just sent by a paralegal somewhere, thinking, well, we're just going to cut the liability off here, and that's kind of it. And I think if you are going to run one of those type of churn and burn shops, you really need to have somebody you can refer cases to that are beyond the scope of what you're capable of doing in terms of manpower. Because if you're running 200-300 cases per attorney, you're not going to be able to have personal contact with all those clients. You probably wouldn't know them well enough to recognize them if you saw them on the street. So you've got to figure out some way to get through that list really fast. Figure out the ones that you can get resolved versus the ones you're going to have to refer out, and handle that in a smooth way, which I think is very difficult to do.
So we've got a question here, and I think it's a good one if I understand it right. It says, I think the recommendation to not sue for non-payment of fees is a great recommendation. However, does that potentially cross the ethics line to not attempt to settle malpractice claims? And they cite the rules of professional conduct 1.8H. To clarify, I would say almost universally in the cases where I see that someone has sued for collection.
Yeah, it comes up after.
Yes.
So you sue them, hey, you're not paying. Oftentimes everything is fine with the relationship.
Right.
Just there's no money. And then they countersue you for malpractice, and they find something
Correct.
that they didn't like on the case. And maybe you're right and they're wrong, but now they have something to negotiate with.
Correct. And that's I want to clarify that in most of those cases, there is no malpractice. There is nothing that the attorney, at least in my opinion, has done incorrectly or negligently. But it's the natural knee-jerk reaction to countersue for malpractice when you're sued for fees.
Yeah, and I don't think, I guess you could take the position that by not suing the client for fees, that's kind of a resolution of a claim with the client. But I think that takes a kind of a weird posture on it, because, just because somebody makes a claim in a lawsuit doesn't mean it's real. And if the client hasn't even discussed a malpractice issue or claim with you, I don't know how deciding not to sue them could be construed as really resolving a ethics issue or a malpractice issue directly with the client. I don't know. I can see where the thinking is going, but I don't
I
think
do,
so.
and I think it's a good distinction to point out. But again,
Yeah.
my experience is that the malpractice is purely a knee-jerk reaction to having been sued for a collection of fees that you owed, not that there actually was malpractice.
Yeah, and you never want to get into a discussion with a client about malpractice, about a bar complaint, or anything like that. Partially because I think a lot of the times where they get filed, the clients, the rare occasion where somebody files one and you didn't do anything, the client thinks it's going to be some sort of leverage over
Right.
you to get something like out of the bill or whatever, and just telling them, you know what, I can't even discuss it. I can't even discuss that with you. It would be against the rules for me to do that, and I don't really have any interest. So if we need to discuss anything else with the case, great. Otherwise, have a nice day. And I think once they see that, okay, they're going to have to go through this whole process, and they're not going to be able to get anything out of you until much, much later, if at all. The bar complaint process, clients don't get any recovery from it at all that I'm aware of, except in some cases like where a lawyer has died or stolen a bunch of money or something. So I think a lot of clients file those bar complaints thinking that they're like a malpractice action. But I wouldn't get into explaining that to them, because you're not supposed to discuss it anyway. But you know, a lot of times those problems go away once the clients sit with it a little bit.
So we're just about out of time, and the final thoughts I had will actually we usually tackle in our ethics CLE, but there are things such as have a fee agreement, don't go beyond the scope of your representation, avoid conflicts. Obviously, all of those matters can get you into malpractice issues, but I think we'll cover most of those in our ethics CLE, so we won't tackle them today.
Yeah.
But again, for me, the big highlights are know your calendar, know the deadlines, know your rules. So calendaring, know your client, communicate with your client, have a personal touch with your client. Calendar and communicate. You follow those two bits and you'll avoid a large portion of the malpractice cases.
I mean, if you avoid panic, don't freak out, talk to people before you react. Oftentimes let things sit a little while before you react and think about them with a cool head. I also like to recommend, I started taking a few years ago a different approach with opposing counsel. I had a therapist give me this 4 Agreements book, and it was very interesting about not taking things personally. And I think, when opposing counsel is jumping up and down or making a big deal out of something that doesn't merit it, that's because of something that's going on with them. And it only becomes about you if you get involved.
Right. And I guess that's the final bit of advice. Give grace where you can.
Yeah.
There'll be a time where all of us fall a little short of what we should probably do as attorneys, and where we can give grace to others, you hope it comes back to you in the end. So.
Amen, brother.
All right. Thank you, everybody. We'll see you at the next CLE.